Well, all right. Good afternoon, everyone. I hope everyone is having a great day so far. Thank you for joining us today. We know that you have busy schedules, and we're glad that you're here with us today. I'm Lee Leppert. I'm the Senior Creative Manager here at the Cromeans Law Firm. And today we have Miss Ieshia Dunmore. She's an Associate Attorney at the Cromeans Law Firm, and she'll be presenting today. Ieshia has been a practicing attorney since 2012 and takes pride in her cases and exhibits a very strong will to win. Ieshia is focused and determined to serve the needs of her clients and always has a heart to help others in need. She cares about her clients deeply, and she's excited to be here today. She'll be breaking down some of the most important key factors today. You must understand to best protect you and your material supply business and make sure that you are paid for every outstanding invoice. As a material supplier in the construction industry, most of your products are sold on credit, and this can be a very scary situation as material suppliers take an enormous amount of risk when supplying material on credit in the construction industry. Collecting what is yours is crucial to the livelihood of your business. And we'll be covering everything you need to know about the credit applications, what information you need to get for every project, how to write off less than 1% of your gross revenue, how to create consistent collection strategy, and why you would also need signed delivery tickets. Please note that we will be having a Q&A at the end of this presentation, so feel free to unmute yourself, ask Ieshia any and all questions you may have, and you can also submit any questions you have in the chat, and I can read them off to her. This is your perfect time to get any and all questions that you want answered by a licensed attorney, so we hope you take advantage of the time. All right, I think people will be kind of trickling in, but let's go ahead and start everything off. Ieshia, go ahead and take it away.
Good, just afternoon, everyone. As Ms. Lee described, I am an associate attorney here with the Cromeans Law Firm, and today we're just here to discuss various ways you can protect yourself as a material supplier here in the state of Texas. As Lee stated, generally when you're supplying materials to projects, these materials are supplied on a credit basis. That means you generally not paid up front. You are required most of the time to provide the materials to the property before receiving payment. This can cause a lot of concern, especially for small businessmen or any businessmen in general, because a lot of times you're seeing your items and your materials and your supplies, your inventory go down without necessarily a guarantee that you're going to receive payment. So our goal here today is to make sure that you are informed in all of your ways that you can protect yourselves in order to secure payment as a material supplier in the state of Texas. Some of the things that we're going to address in today's webinar are going to be the credit application and what information should be in your credit application. Also ways that you can write off less than 1% of your gross revenue. Lastly, we're going to discuss as well how you can create a consistent collection strategy and why you need signed delivery tickets. So if any of these things sound useful to you, I would definitely stay tuned. If, for example, you're not using delivery tickets or you don't know what a credit application is, you can get that information here as well. So to move on with the first topic, what should be in your credit application? The first thing that you really want to know in your credit application is that it does not have to be a very lengthy, complicated process. You just want to make sure that you have the right information in the credit application. So the most effective things that you want to make sure are in your credit application are going to be the general information, your credit terms, and a personal guarantee. The reason that you want this information in the credit application is because the credit application, it kind of acts as the contract between the parties governing how the future series of events is going to occur between you. So you can describe this as describe it as a master services agreement or a credit agreement, but it is important that all of the terms of credit are described within the actual credit application. What this means is that you're going to describe how you expect to receive payment, when payment is due. There can also be items listed as far as penalties are concerned, for non-payment or deadlines for payment. A lot of times I see grace periods for payment within these particular credit applications. And so another thing you also want to include as well is an attorney fee recovery clause. Lots of times the law does provide for you to recover your attorney fees. However, if your particular cause of action does not allow for the recovery of attorney fees and you do not have that language in your credit application, you won't be able to recover your attorney fees, which is very important because a lot of times the cost of litigation or the cost of collection, if you don't do this properly, it can over or outweigh the actual cost of the materials that you supplied to the project. So again, for clarity, in your credit application, you definitely want the general information. That's your standard. What is their address? What is their business name? Sometimes people are doing business under their own name. Sometimes they have an LLC or an incorporation. You want to make sure that you have any and all trade names listed for the particular contractor that you are going to be supplying materials to. And that goes to the portion where it says what type of entity are they? Again, are they incorporated? Is it an LLC? Is it just, a sole proprietorship? Who do you talk to when it comes time to pay your bill? Again, that's important to be on the credit application. You want to have a line that describes the primary point of contact for payment. That way later on, it's already established in writing who it was that you were supposed to contact in order to get paid for your services. That's pretty much it for the credit application. Some of the other information that can be included is going to be the individual social security number. The reason this is important is because when it comes down to collecting, a lot of times it's very difficult to find the assets of the debtor or the contractor. And so if we have their social security number, it allows us to do a skip trace or bank financial research in order to locate their accounts. The one last thing I did want to cover here on credit applications is the importance of the personal guarantee. As you can see, it is listed in bold on this slide. The reason a personal guarantee is important is because when you're dealing with an entity, a business that's incorporated or that has an LLC behind its name, generally those business entities are set up in order for the individuals to avoid liability. What this can lead to in business practice is contractors can form these companies, and then if a project goes south or they're not making enough money under the company, or for example, they get a judgment against them under that company's name, they can either move the assets over to the individual's name, or they can simply file bankruptcy in the name of the company and wipe that debt away and move clear forward scot-free. In order to avoid that, it's very important to get a personal guarantee. You want to have that personal guarantee preferably from some sort of officer, director, or manager of the company. And what this allows is it allows you to also hold them liable in their individual capacity for any labor or materials that you have supplied to the business or a project or the account in which the credit application is for. Again, this is important because it's a lot more difficult and it's a lot harder of a decision for an individual to file bankruptcy as opposed to a person. And you always want to make sure that there's plenty of pockets for you to seek your money from. Lee, if we could get the next slide, thank you. Okay, trade references. This is also important to be included on your credit application. The importance of trade references is you just kind of want to make sure that this person has a good reputation in the industry. A downfall here a lot of times is that clients will ask for trade references and list them on the credit application, but they won't go through the trouble of actually calling them before they do business. It can be time consuming. You know, this is a task if you're in management that you can delegate possibly to a lower tier administrative assistant. However, it is important that you actually obtain these trade references and give them a call. You want to ask, you know, what the history of business is. How long have you been doing business with this contractor? Are they consistent in providing you payment? Contractors who do not provide payment are known to consistently not provide payment. Unfortunately, they do get that reputation, and this can save you a headache in the end if you find out that, you know, they're just not a reputable company. Now, again, to go into further detail about the credit terms, this is where the actual terms of the agreement between you and the contractor are going to be located. It's going to lay out, again, when payment is due, what will happen if payment is late, what will happen if there's interest charged, or who's going to be responsible for attorney fees. This is a very important clause because you are not permitted recovery against all type of entities when it comes to attorney fees. However, you are always permitted recovery of attorney fees if it is in your contract with the parties. So you want to definitely make sure it's clearly outlined in your credit agreement that any collection efforts you will be compensated for in the event that payment is not timely made. Now, again, here's some further details about the personal guarantee. You can feel free to read through these details as I speak. But again, as I described previously, the importance of a personal guarantee is to make sure that you have another person on the hook for the bill. The more people that you have on the hook for the bill, the better. And an individual is always better than a company in order to secure payment from. Lots of times companies can avoid payment, especially if they're smaller companies, simply by filing bankruptcy or moving around assets. And so in order to save your money on collection costs and to make sure you have several avenues of collection, make sure that you get a personal guarantee from some sort of manager or officer of the company that you are deciding to enter a credit agreement with. Okay, so this is very, very, very important here. What information do you need to know when you're starting to supply material to a new project? This is very important because one of the most effective remedies for material suppliers to obtain payment for outstanding balances is a mechanics and materialman's lien. A mechanics and materialman's lien is a statutory remedy, which means that in order to recover on a lien or to properly perfect a lien, you have to comply with the statute. The statute outlines several different types of notices that need to be sent, what they need to contain, when they need to be sent, and also to whom they need to be sent. So when you're starting to supply materials to a project, it's very, very important that you find out up front who you're working for. You want to know who you're working for, who your contract is with, who you're supplying the materials to. From there, you need to know what their status on the project is. Are they a subcontractor on the project? Are they the actual general contractor on the project? You need to know who the owner is on the project as well. Now, this is important because, as you may be aware, material suppliers are very far down the chain when it comes to claimants. Many times you'll have in first place the owner who contracts with the general contractor. Then the general contractor may hire several subcontractors to complete the project. From there, generally, the material man is hired as the fourth party, by the subcontractors. In order to effectively perfect a lien in the state of Texas, you are absolutely required to send notice to all of the parties up the chain. That means that if you are working for a subcontractor, you need to send him notice. You also need to send his general contractor notice, as well as the owner. Because Texas is a big state, there is no system that we have to date where you can simply look up and find out who the general contractor on the project is or who the subcontractor is on the project. So for clarity, in the event that you are working a municipal project, right, a city or a state project that is covered by the government code, in those particular instances, it is public record who the general contractor and subcontractor is. However, those government projects are very large and also very limited. The majority of projects that we see completed in the state of Texas are going to be private contracts. And so in the instance that you are working on a private property for a private owner, there's nowhere where you can go to definitively find out who the subcontractor and who the general contractors are if you did not get this information up front. And so again, you want to make sure that you're collecting this information, because if you don't, you could run the risk of not properly perfecting your lien. And if that happens, you will lose the greatest right of recovery that you have for any unpaid monies. Okay, next up to discuss is ways to protect yourselves when you're supplying materials to a homestead. As you may know, Texas is a very debtor-friendly state. We have a lot of protections for our debtors here in the state of Texas. A homestead protection is one of the debtor protections that we have. The way that homestead works is that if a person or resident of the state of Texas declares that their residence is their sole residence and intended to stay there on a permanent basis, that they now get homestead protections. What that does is it prevents creditors from being able to collect against the homestead. So for example, if you sue someone in the state of Texas and you get a judgment against them and they have a homestead protection on their home, you're not allowed to collect that asset. So because of the homestead protections on Texas homes, it makes the lien efforts a little more difficult when you are supplying materials to a homestead. Now, this is not to say that a homestead lien cannot be perfected. It can be perfected. You just need to follow the proper steps on the code, but it does make the process much more difficult. So when collecting information about your project, you need to find out up front if it's a homestead. And so if the project is commercial, this is not something that you need to worry about. However, if you're working on a residential property, your red flags should automatically go off, and you need to know immediately if this is someone's residence, if it's their homestead. Now, the good news here is that unlike the inability to search to find out who a general contractor is or who a subcontractor on a project is, the state of Texas does have for public record all of the homestead exemptions that have been filed in our state. And so all you would need to do if you are working on a residential property, go ahead and go to the county in which that property is located. So for example, if that property is located in Harris County, you would go to the Harris County Appraisal District website. Again, if it's in Fort Bend County, you would simply do a Google search for the Fort Bend County Appraisal District website. Nowadays in 2021, virtually every county, even small counties, have an online record of their appraisal district website. If you look up the address where you are performing labor or if you're supplying materials, if you look up the address, you will be able to see what exemptions, if any, have been filed on the property. Now, it is important to note that even if you do not see a homestead exemption filed on the property, that does not necessarily establish that there is no homestead exemption. It is your, it's the best you can do at that point, but there is some wiggle room in the law for the homeowner to argue that basically, even though, they didn't file the homestead, that they do live there and they actually intended the property to be their homestead. But that is a burden for them to overcome. And if they have not filed that exemption, it is safe for you to make the assumption that it is not a homestead. But you definitely want to get that information and do your due diligence and make sure you look up that address yourself. Okay, securing your right to payment. I've talked a little bit about this already, but again, the best way to secure your right to payment for a material man in the state of Texas is through a mechanics and material man's lien. Now, this is the same for anyone who is supplying, whether it be labor or materials, to real property in the state of Texas. This can be residential property or commercial property. But the benefit of a lien is because in the eyes of the law, by providing labor and materials to the property, you are therefore improving the value of the property and you are benefiting the owner by your improvements. With that said, that gives you a ownership interest in the property. Well, once you file a lien that's been properly perfected, that is what gives you the ownership interest in the property. The lien is very essential to the material supplier. And in order to get such an extreme remedy, being that now you have an interest in the property, you do have to make sure that the statute is followed in order to perfect those liens. If you miss a step, then you may lose the right to collect your lien. Again, on homestead liens, these steps are much more extensive, but whether it be a standard mechanics and material man's lien or a homestead mechanics and material man's lien, it is important to seek the advice of counsel before filing these liens in order to make sure that you have complied with all of the statutory requirements. And if I may, I would also like to add that immediately once you don't receive payment, I would say once your invoice is about 30 days unpaid, this is when you need to be contacting an attorney. A lot of times I get clients that contact me, they haven't been paid in 6 months, they haven't been paid in 8 months. Well, unfortunately, at that time, your right to lien has already expired. Notices have to go out within a certain time frame before the lien is even filed, and then generally the cutoff for the lien is going to be 4 months after that actual labor or material was supplied to the project. And so if you've worked a project that consists over several months, then it's easy for you to see that, if you're doing work in January and you haven't been paid for it, and here comes to be March and April and you're still providing work or supplying materials to the project, but you haven't collected on January, you're going to start being untimely for some of the materials that were supplied at the beginning of the project. So it's important to note that everything as far as timelines and deadlines under the statutes for perfecting liens is completely dependent on when the labor or materials was supplied to the project. And that would be the month and the year. Okay, so next up, is there a kink in your cash flow hose? The rules and steps for a valid lien are different in all 50 states. So today we're primarily focusing on Texas, but it is important to note that lien laws are not going to be the same in all states. So if you have an if your business crosses state lines, or if you perform services in other states, or if you travel for work, this is something that you want to be aware of. You want to make sure that you're familiar with any lien laws in the state that you are actually supplying the labor and materials. Also, you want to remember that in almost all states, because the money in a project flows downhill, there is generally going to be a notice requirement. And so that goes back to the 4 positions that I discussed earlier: the owner, the general contractor, the subcontractor, and the material man. So because the money flows from the owner all the way down the trail, it's very important that the owner, the GC, the sub, gets notice before a lien is filed. And because many times the general contractor or owner could actually be providing payment to the party that you have a contract with, but they're just simply not passing that payment along to you. Okay, so if there's an issue with the money and it's not making it down the food chain, then that is when you're wanting to make sure to go ahead and get those pre-lien notices out. Again, that's definitely applicable to Texas, and it is also applicable to the majority of the 50 states due to that downflow of the cash. This is accomplished by simply sending a notice to the owner or general contractor that there is a subcontractor whom you have supplied materials for. Those materials have been incorporated and delivered to the property, and you have not been paid. This sometimes, especially under the state of Texas, I cannot speak to the other 50 states, but in the state of Texas, what this triggers is this allows now the owner or general contractor to withhold funds that are owed to the subcontractor who owes you. And instead of paying those funds to that subcontractor, they can skip him in the chain and go ahead and provide payment to you. So again, as soon as you realize there's an issue and you're feeling like you're not going to get paid, you go ahead and send notice to the owner and general contractor. I did advise to contact an attorney. I still believe that is true. What I would suggest is send some sort of written notice to the owner and general contractor via certified mail at their address. And once you've done that, go ahead and immediately contact an attorney. Only because, once again, there are requirements pursuant to the statutes of what the notices have to have, who they need to be sent to, what kind of language they need to include. And there's a lot of case law that will invalidate your entire notice based on not following the statute completely. So again, giving notice to the owner and general contractor is the name of the game, and the safest bet is to hire an attorney to make sure that your notices are in compliance with the lien statutes. Lastly, the purpose of this notice is twofold. It not only begins your countdown for your lien rights and begins the perfection of any lien rights that you have, but it also gives the owner or a general contractor an opportunity to provide payment directly to you, and you don't have to deal with the individual contractor that's not providing payment. All right, your collection strategy is the key. The whole goal of today's webinar is to make sure that you're protected and make sure that your collection efforts are as strong as possible. So most material suppliers do have 30-day terms. This allows for contractors to, again, obtain materials on credit and provide payment for those within a 30-day turnaround. We all know, however, though, in the construction industry, nothing rarely ever happens within 30 days. So the importance of this is that you want to make sure that even though we know it's very common and very standard for payments not to go out within 30 days, you have to protect yourself. Okay, you can't be the nice guy. A lot of times I have clients, they say that they haven't sent a notice or they haven't requested their money because, they don't want to make anyone upset. They don't want to aggravate the project. And, the payments are late. They know it's coming. They have a good relationship. But my question is, okay, so what happens when payment doesn't come? Now you were the nice guy and you didn't send a letter. So now you're not going to be able to secure your lien rights at all. The better thing to do is send the letter with a short email to say, hey, I know you guys consistently pay pretty late, but I'm sending this notice just in case to make sure in the event that it's not paid, I'm securing my lien rights. That way they know that you mean business. It's a friendly message to them. They know that you're still waiting for payment in a calm manner. You have no intent on filing a lien immediately, but you've also secured your right to lien the property at a later time. Okay, so what is required for the lien notices? Again, you can take a look at the statutes, and you can also read these slides in greater detail. However, in a nutshell, the first notice that you need to send is going to be to the general contractor. He is the one who generally is responsible for payment of all the lower tier subcontractors. Thus, he's also responsible for payment to their material suppliers. So this notice needs to be sent on the 15th day of the second month after the material was first supplied. So if you're supplying materials in January, you need to send a notice to the general contractor if you have not been paid by the 15th of March. So this means in your collection department, as far as your accounts receivable, somebody needs to be on your books on the 10th of every month to check back 60 days prior to see what materials were supplied. If any of those materials have not been paid for, these pre-lien notices need to go out to the general contractor. Again, this is not to say that you need to stop working or you need to burn bridges with your contractors in the meantime, but they need to know that you're not paid. You're still supplying materials to the property. Maybe you're patiently waiting, but now they're on notice that you haven't been paid and your lien rights are secured. So the next notice as a material supplier in the state of Texas needs to be sent the 15th day of the third month that you first supplied the material. Again, going with the January metaphor, this would be April 15th. So the second notice going out on the third month, 15th day, this particular notice needs to be sent not only to the owner, but it also needs to be sent to the general contractor. So now at this point, the general contractor should have been on notice from our March 15th notice that our January materials had not been paid for. At this time, we still have not received money. And so now we're going to send another notice. This time we're going to address the notice to the owner, and we're also going to send a copy of this notice to the general contractor. And we're going to let the owner know, hey, look, we've supplied some materials in January. We sent a notice to the general contractor in March. We still have not been paid. Now, this particular notice, it's not mentioned on the slide. However, this particular notice does have some pretty significant statutory requirements. Because if you are able to perfect a lien, you now have an ownership interest in the owner's property. Texas does consider this a very extreme remedy. Because of that, there are some explicit language that needs to be on that notice, letting the owner know that should he continue to fail to pay, that a lien right may arise and you could have an interest in his property. Okay, so the essential facts, just in a nutshell, the the actual lien needs to be filed the 15th day of the fourth month after the last supply of material or within 30 days of the project's final completion. You do not have to file a lien for every month that material was supplied. You can file only one lien for everything as long as you continue to send your notices. And so that goes back to what I was saying up front, how you just want to make it standard practice to send these notices at the 60-day mark once your materials are not paid for. You can just continue to send notices throughout the entirety of the project. And then once the project is over, if you're not paid within 30 days of completion of the project, go ahead and file your lien. Again, the expiration time frame is that 30th day, so you do want to file the lien before then. But the importance of the notices is that now, even though you've waited to the end of the project to file your lien and you've been respectable, you've allowed people time to pay, you have not lost your lien rights to all of the materials that you've supplied possibly several months ahead of time that possibly would be untimely had you not have sent those notices. Again, a copy of the lien that is filed needs to be sent to the general contractor and owner. This is a statutory requirement for perfection of the lien. So once you do get it filed, you need to send a copy to the GC and the owner within 5 business days. All notices required to be sent must be sent certified mail return receipt. There are some safety nets in the event that they actually received it, but you did not send it that way. But your best bet is to send it certified mail return receipt. There is a caveat in the statute that says if you comply and you send it certified mail, all you have to prove is that you gave it to the post office, right? You don't even need to prove that they received it. So in order to be the safest that you can, go ahead and get that sent certified mail. Again, the only way to prove beyond a doubt that the letter was sent on a specific date is to take it to the post office yourself. Now in 2021, a lot of people aren't going down to physically go to the post office. However, in these particular instances, you want to make sure that you go to the post office, because when you go in, they give you a physical date stamp on your envelope that shows when it was sent, and that's what you're going to need for evidence for court. Okay, the lien again is the extreme remedy, so you need to make sure that you're following the rules exactly. Any deviation from the deadlines in the statute can completely invalidate your lien. And even if it seems like a small slip up, the lien gives you a right in the property. And so your only guarantee to a lien is through the statute or through the Constitution if you're actually a general contractor. But today we're only talking about material suppliers. And so for material suppliers, your only shot at a lien is through the statute. So with that said, any slip ups can be extremely detrimental. It's also important to remember that if you file a lien on someone's property and you have not done it correctly, they can sue you to get that lien removed, and you will be liable for their attorney fees should a judge find that their attorney fees were reasonable and necessarily incurred because of your invalid lien filing. Okay, material supplier defense. What does Texas require? The materials not delivered here is the most common defense to a material supplier lien. This is correct. We are required to prove delivery. Now, there are two ways to prove delivery. We can prove that the materials were actually delivered to the project job site, or we can prove that the materials were delivered to a specific contractor or builder for use at the job site. With that said, this is the purpose of these signed delivery tickets. It's very important that you get signed delivery tickets when you're supplying materials. It's even better if these delivery tickets are informative. If they say who's signing for the materials, what company they are from, and what project these materials are being supplied to, that's the best information. These delivery tickets can be used the same whether the builder is picking them up at will call or whether the materials are actually being supplied to the property. And this is because, again, we are permitted to permit either delivery to the project or delivery to the builder for use at the project. So what does Texas require? Towards the end of that other slide, it did make mention that some states do actually require that the materials be incorporated into the property. However, Texas does not require actual proof that the materials were incorporated into the project. All it requires, again, is that the materials were delivered either to the project or to a specific contractor for use at the project. Texas does not require you go the extra step to actually prove that the materials were incorporated into the real property. And so that's good, because the signed delivery ticket can be exclusive or establish the evidence that actual delivery of the material took place, and that can eliminate any requirement for delivery. Okay, so as I stated, the signed delivery tickets are the key to success. Following the statute absolutely guarantees your lien rights, and perfecting your lien is the first key. But again, the most common defense that the contractor or the owner may use is that the materials weren't actually delivered. If your evidence conclusively establishes that the contractor that you had a contract with received those materials for use at the project, then it's very difficult for any defendant to overcome that. It also makes your case a lot easier to establish on a motion for summary judgment, which is an expedited procedure in the law. You may not be aware, but a lot of jury trials take anywhere from 2 to 3 years to get accomplished. If you would like your case resolved within 6 to 12 months, this is the type of evidence that attorneys need from you. So you want to make sure that you're covering all your bases to make sure that you're collecting and keeping all the evidence that you need should you need or should you not be paid for your services. Another reliable source of evidence is documenting the material that had to be specially fabricated for any specific project. So for example, if you did a custom made window or a custom made paint type job, just document any internal documentation that you can create or supply that evidences what steps you took to specially fabricate that material would definitely be beneficial in proving your lien. All right, so for someone claiming that your material wasn't used on the project, it's just that easy. We investigate to find out what's going on, and it's pretty evident that your material is going to be used in the project, especially if it's a specially fabricated material. If you have described how the material was made, if you've possibly taken pictures of it, specially fabricated material is going to be unique to the maker. And so your evidence, especially fabricating the items, is going to make it pretty much a slam dunk case that those actual materials were not only delivered, but further that they were incorporated into the property. So make sure that you're covering your butt every day. You want to prepare for unknown circumstances in your business. Again, you want to preempt being unpaid. Not being paid as a business is a part of business. Most businesses do have collection activities. They do have some unpaid items on their receivables. So with that said, you just want to make sure you're covering your butt and ensuring that you have all of the proper evidence and all of the proper upfront protections to make sure that your collection activities are successful. By gathering the things that I have discussed today, you will secure your lien rights. You will make sure that any collection efforts by your attorneys are minimal and as well as successful. So thank you guys so much. I think I talked a little bit longer than we expected, but if you guys have any questions or anything like that, feel free to let me know.
Thank you, Ieshia. It was great. You're very informative and very fun to listen to.
Sometimes a little too much, but
no, you're thorough and I like it. You put it in plain English for me, so I understand it.
Good.
Okay, so any questions you may have, this is your time to send anything in the chat. I can read it to Ieshia. You're also welcome to unmute yourself and ask any and all questions. Okay, well, if we don't have any questions for Ieshia, thank you all for joining us today. We are so grateful for your time, and we hope you join us in the coming months. Thank you so much.
Thanks, guys. Take care. Bye-bye.